Yeah. All right, we're going to go ahead and call this meeting to order. It is January 6th at 5 o'clock. We're going to convene Land Use and Zoning Committee with introductions to my left. And we'll come back to you, Ms. Pittman. Take your time. Go ahead, Mr. Councilmember Gay. Go ahead.
Mike Gay, District 2, just visiting.
Reginald Gaffney Jr., District 8.
Rockman Johnson, District 14. Good afternoon.
Joe Carlucci, District 5.
Raul Arias, District 11.
Good evening, Terrence Freeman at large, Group 1.
Randy White, District 12.
Terrence Harvey, Office of General Counsel.
Susan Kelly, Planning Department.
Aaron Abney, Planning Department.
All right. Thank you for all the introductions. We already kind of went through the agenda and the agenda meeting. For those of us who weren't tuned in yet, we're going to go to page 8, 8 of 11, item number 16, 2025-845. This is, and Ms. Pittman, if you want to announce that you're here, you may. We don't want to.
New Year's and Councilwoman Jacoby Pittman from District 10, the Mega District.
The Mega District. And this is the one that you are here for. So, this is going to be an appeal. So, committee members, this is kind of a different process, and we're going to have Mr. Harvey kind of explain it to us, but this is the one we're going to be taking up first. So, we'll go through ex parte. We'll kick it over to Mr. Harvey. We'll get an explanation on how this is going to go, and then we will hear from the we'll hear from the applicant and then the appellant or whatever, and we'll go from there. So, council members, if you have any ex parte, please declare it at this time. Councilmember Arias, you're recognized.
Thank you, Mr. Chair. I'd like to declare ex parte. Yesterday, January 4th, I think it was the 5th, I received a phone call from the applicant to give me more details on the nature of the appeal, and it's currently being filed with Legislative Services. Thank you.
Councilmember Johnson, you're recognized.
Thank you, Mr. Chair. I rise to declare ex parte. I reached out to the applicant. I spoke with him on yesterday I had some questions about the distance lines. That information is currently being filed with Legislative Services. Thank you.
Councilmember White, you're recognized.
Declare ex parte. I had some questions myself, and I spoke to Mr. Hard in a couple of days, and everything will be filed. Thank you.
All right. No one else, so I also declare ex parte. I had a conversation with Mr. Harden, and we talked about the appeal and some of the timing that goes around it, and this paperwork will be filed with Legislative Services. So with that, Mr. Harvey, if you will, please kind of give us an explanation of how this process works, and we will hear from you.
Thank you, Chair. Section 656, 140 through 146 of the Ordinance Code provide the procedure for an appeal of a decision by the Commission, the Planning Commission, on applications for zoning variances. The LUZ Committee, as the committee of reference to the City Council on such appeals, will hold a hearing and provide a recommendation to the City Council. Pursuant to Council Rule 6201 and Section 656 of the Ordinance Code, this is an informal quasi-judicial hearing. No formal hearing was requested by the appellant. The order of the presentation will be as follows. After the disclosure of ex parte, which has already been done, the public hearing will be opened. There will be a presentation by the appellant, who is represented by Paul Harden, and then the appellee will have the same 10 minutes of time. Each party would have the opportunity for rebuttal to be reserved within that 10-minute time. We will then go to the public hearing, which will be 3 minutes for each individual, and then that rebuttal by the appellant if necessary. And then we'll close that public hearing and take it back to the body for deliberation and vote. The decision must be based on competent substantial evidence, which means it can be expert testimony, staff, and expert reports and information that is received from the public that has personal knowledge of the material facts. One thing to keep note of: this appeal will be done under de novo or request de novo, which means that a presentation of all the evidence starts over again. And so the appellant and the other presenters may provide you with additional evidence that was not provided in your transcripts that you have in the report that was provided with this application. Other than that, Chair, I'll turn it back over to you.
All right, and I did forget one important thing, and that was to recognize our pages. So sorry about that, ladies and gentlemen. We have Miss Leah Schaefer right over here from Wolfson High School, and we also have Adeline Campbell right over here from Palmer Catholic Academy. Thank you all so much for coming, and we hope you get a good experience out of this. So with that, we will go to Mr. Hardin for 10 minutes. And then we will hear from planning for 10 minutes as well. Mr. Hardin, go ahead.
Thank you, Mr. Chairman. Paul Hardin, 1431 River Place Boulevard. I don't think I'll take the 10 minutes. The issue is competent substantial evidence as to the criteria for the appeal. Those are listed on the last page of the handout that you received from the General Counsel's office. Each of those items is addressed in the transcript from the Planning Commission. Mr. Huxford represented Ms. Brock at that Planning Commission. He addressed each of those criteria and stated how we met each of those criteria. But by way of background, this is a request for a variance from the 2,500 feet distance limitation for a sexual predator living next to a daycare center. This daycare center has been at this location for over 2 decades. That's more than 20 years. The predator, the person alleged to be a predator, moved in, or the record indicates that he purchased a house some less than a year ago in the neighborhood. The daycare that's operated there, the operator of that unfortunately passed away about a year ago. My client, Ms. Brock, purchased the daycare and the operation of that facility as it had been operated, exactly as it had been operated for 20 years. There have been no issues related to a predator or any predator. But to put things in perspective, the law requires, and this how they came up with 2,500 feet is known only to God and Mr. Crescentbenny, but it's a requirement for the distance for the predator to be that far away from the daycare center. In fact, in this particular case, it's right at 2,000 feet, so it's a variance from 2,500 down to 2,000. But if you know this neighborhood, and Mr. Gay will know it, but it's right next to Jackson High School. It's across Main Street on 25th Street. To get to where the predator lives, you have to go some 2,100 feet or 700 yards, if you will. So picture 7 times the length of the Gator Bowl, of the football field, before you get to the predator location. That means you'd cut across Main Street, you'd go through the main building of Jackson High School, you'd go through the gym of Jackson High School, you'd go to the outdoor facility, you'd go to the neighborhood, you'd go across Pearl Street and down Golf Fair before you got to where this person lived. In between that location, where the predator allegedly resides, and the daycare center are 3 other daycare centers, a senior high school, and those are all listed at their location. All are closer than the 2,000 feet in this situation. So we think that under the facts and the criteria that the waiver should be granted. There is a great need for daycare in the neighborhood. This provides daycare for folks who work in the area. It meets each of the criteria. There are practical and economic difficulties because they're both located where they're located, and we can't lift them up and move them to a different location. It's not the request is not based on a desire to reduce the cost of the operation. It's operated the way it's been operating, as I said, for some 20 years. The proposed variance won't diminish property values. The property values are set. As I say, it's been there for 2 decades, so it won't have an effect on property values. And the effect of the proposed variance is in harmony with the spirit. The spirit and intent of the zoning code is to separate these 2 particular uses. In this particular case, it's separated some 2,000 feet away, and in between that, in that 2,000 feet are multiple homes, multiple businesses, as I said, daycare centers, and a very large High School, PS 35. So with that, I'll sit down and I'll be happy to answer any questions after the presentation of the Planning Department. Thank you, Mr. Chairman.
All right, thank you. Ms. Abney, are you going to go down to the podium? I think that's normally the proper protocol. I don't know, but that's how it was last time.
Okay. Aaron Abney, representative from the Planning Department. So this is Ordinance 2025-845, which is seeking to appeal the Planning Commission's denial for variance 2522 for a property that's located at 15 25th Street East. This application is seeking to reduce that distance from a daycare and a sexual predator from the 2,500 feet required by Part 4 standards of the zoning code to 1,980 feet. The subject property is zoned CCG1, which does allow for daycares by right when it meets the performance standards and development criteria of Part 4 of the zoning code. Part 4 states that after January 1st, 2015, a new daycare center shall not be located within 2,500 feet of a sexual predator residence. The change of name or continuation of a daycare center within the same location that has been operating within the last 6 months by any party shall not be considered a new daycare. The subject property has historically operated as a daycare center since records say early 2003, but has since been closed and non-operational for longer than 6 months. And so therefore it is considered new and must abide by the distance regulations from the sexual predator. Florida law the variance also does request some reductions in setbacks, buffering, and parking in order to bring the site up to zoning code, but the main issue today is the sexual predator distance. Florida law prevents convicted sexual predators from residing within 1,000 feet of schools, child care facilities, parks, and playgrounds, but the section of Jacksonville Code 685 for sexual predator residency requirements expanded this zone of protection and prohibits sexual predators from residing within 2,500 feet of a school, public library, daycare centers, parks, playgrounds, and other places where children regularly congregate. And that was approved back in 2005. The sexual predator purchased his property in March of 2004, so prior to the city's expansion from the 1,000 feet to the 2,500 feet, and then also was prior to the Part 4 zoning code regulations for daycares, which that came into effect December of 2015, as to why the code says anything after January 1st, 2015, new daycares have to abide by this regulation. Staff reviewed the request and did not make a positive finding on the variance criteria. Staff does not find that the request is consistent with the definition of a variance that is defined as a relaxation of the terms of this zoning code, which will not be contrary to the public interest and where owing to conditions peculiar to the property and not the result of the actions of the applicant, a literal enforcement of the zoning code would result in unnecessary and undue hardship. The grant of the variance and the relaxation of this distance limitation is not clearly in the public's interest. The enacted ordinance was put into place in order to protect children and to create a separated buffer between child care facilities and sexual predators. So because of these reasons and those also outlined in the staff report, the department recommended denial. The application was heard by the Planning Commission on October 9th, where there were no speakers in opposition, just the applicant and their client. The commission voted to deny the application unanimously 7-0 for the following reasons. They cited the spirit and the intent of the code and the legislation for the increase of that distance to 2,500 feet, again, is to protect children, and by approving a reduction does not promote that spirit and intent of the code. Also, while there is one sexual predator approximately 1,980 feet away, they noted that there are several sexual offenders within the immediate area. The closest one is just a couple properties down. So the commission felt that the location was not appropriate given the number of both sexual predators in the area and offenders within the immediate area. So because of those reasons, the commission voted to deny the request unanimously. And that's it for me.
Okay, thank you. Did you say the Planning Commission voted to deny?
Correct, yes.
Is that
So
what you're
the-
saying? Okay.
Yeah, so Planning Commission voted to deny, and then this is the appeal of that Planning Commission decision.
Okay, sorry, I didn't see that noted on the agenda. All right, so Mr. Harvey, where do we go now that we've heard their remarks? Do we go to the rest of the speaker cards, or do we open it for questions immediately, or?
No, Chair. Mr. Hardin does get rebuttal time, so
Okay.
he didn't use his full 10 minutes, so the remaining of his time is to be.
Okay, all
I
right.
want to respond to.
Yes, sir. Okay, go ahead, Mr. Hardin,
Let me
your
start
rebuttal.
Backwards. I'm sorry, go ahead.
Yep, go ahead.
Okay. Well, I go backwards. She cited to other alleged offenders in the area. Those are not part of the record. That's not competent substantial evidence as to any issue with regard to the variance. The context of the hearing is not really brought out by her explanation. There were no speakers whatsoever from the audience. The only person who spoke was the chairman of the Planning Commission. The chairman of the Planning Commission reiterated an anecdotal story regarding his life and some activities regarding his life, and that he felt like that the law was a good thing to be in place. That was the only speaker. No one spoke to any of the items that have to do with the variance and the criteria. So the only speaker was the chairman speaking about his personal experience. We believe it is in the public interest to provide daycare at an affordable cost for this particular neighborhood. I think Ms. Pittman may comment on that, and we believe it is in the public interest. Remember, the state law only requires 1,000 feet, and we're clearly within that. The local law ordinance is 2,500 feet. Erin went quickly through several of the criteria, not all of them. If you'll note, she doesn't cite any positive evidence. She said they didn't find anything to prove it up. Doesn't mean they found things to prove it down. That's not competent substantial evidence. Competent substantial evidence is evidence to the positive, explaining why it doesn't meet the criteria. And we, on the record, Mr. Huxford went through each of those criteria. As you know, he was a long-term employee of the planning department and rendered an opinion that the request met each of those criteria. There's an issue I didn't want to get into about new daycare, old daycare. It's clearly not an old daycare. It's clearly not a new daycare. It's clearly an old daycare. It's 20 years. If it had not been shut down for the 6 months period of time, then you wouldn't have had to file. And I'm not sure why we had to file the application anyway. But to call a daycare that's been continuously operated, except for some short periods of time, in the same manner by the same operator for 20 years, a new facility or a new daycare is I think not a fair reading of the law. My client bought this after the operator who had operated it for 20 years passed away. She was not aware of the fact that this particular person lived 1,980 feet away. It doesn't show up on any of the zoning records. It doesn't show up. So certainly she would have taken her life savings and invested in a business that she wants to continue to operate in the neighborhood she serves if she thought that there was a violation. So I think that's a fact you should consider, that she made a substantial investment in the daycare that had been operating since the person lived there, although there was no way to prove up when and where he lived there. So with that, I'll be happy to answer any questions. Otherwise, we would request that you grant the variance. I think Erin indicated there were some other variances related to the building itself. They've been there for more than 25 years. It was built during when the setbacks were a different length, when the landscape ordinance was different. So those, I don't think the planning department has any objection to bringing those into compliance if you grant the distance to allow the building itself as constructed to be in compliance. Thank you, Mr. Chairman.
All right, thank you, Mr. Hardin. That concludes the presentations from the appellant and the applicant, correct, Mr. Harvey?
Correct.
Okay, so now do we go to the public speaker cards and then we'll bring it back to the committee? Okay.
Yes, sir.
Awesome. So first speaker we have is Tanya Brock. Okay, my apologies. I see that. Questions only. And then we also have folks Huxford in support, as well as Tanya Brock was in support, and they're here for questions only. So with that, I don't think we even opened the public hearing. So, whoops. The public hearing is, well, let's keep it open for now, and we'll go to questions, and then we'll close it, and we'll vote, and we'll go from there. So, committee members, if you have any questions, go ahead and pop in the queue. We already have one. Councilmember Gaffney, you're recognized.
Thank you, through the chair. Mr. Harden, if you could come up.
I think we'll win by 3 touchdowns.
Hey, hopefully we can win 3 touchdowns and go to the Super Bowl. So, excuse my ignorance. You might already answer this question. Your client, I hate using the word predator. Your client, when did he purchase his home? What's it, she?
Now, my client is the daycare operator.
Okay. So she's a daycare operator.
She purchased it less than a year ago, but after the time that the lady who owned it before passed away.
Okay,
so within the last year, but it had been operated for 20 years, more than 20 years.
Gotcha. Okay, and the sexual predator, he been there since, I guess, since when?
Well, he purchased the property, I think, 2004. How long he's lived there or whether it's been continuous, I don't know. And in fact, the fact that he purchased it doesn't mean he lives there. Okay. And we raised that issue at the Planning Commission as well. So, yeah. But that's that we don't disagree with the date Aaron's raising.
Okay. Through the chair, I guess. So, if she purchased this property, I guess the daycare a year ago, why are we just help me out? And you might already answer this question.
She began operating it, and then the issue was raised about the distance. And in the interim, she's been trying to resolve the problem, and it's come to a head by these hearings.
Gotcha. Okay. I'm just trying to get some clarity in terms of the dates and like when it's happened. Okay. So that's all I have for right now. I'm just trying to get an understanding of it so I could better make an informed vote. Okay. Thank you.
Okay. No problem. Councilmember Johnson, you're recognized.
Thanks so much, Mr. Chair. I guess that kind of goes into my question through the chair, and this may not be for Mr. Harden. I'm not sure, but if the daycare was already operating at this time in this space, is there something, and forgive my ignorance of not knowing all the rules, but is there a law that prevents someone who does have a predatory thing on their record from purchasing a home that is near the facility?
Let's don't use the word purchase. Let's use the word reside because that's
reside, purchase, rent. However,
yes, there would be. So if the daycare was there,
right, which it was, as we know,
and if it was not a new daycare, or his old daycare, then the violation would be by the predator, not the daycare operator. In fact, we're not. Yeah. So your point was well taken that he or she couldn't move in and cause us to be in violation if he's there already.
If the center was already there was the death of the previous owner. Can someone from the general counsel's office maybe speak to that? Do we know, and obviously you might take some research through the chair, do we know that law, and was a law violated by the individual moving into that space? And if so, let me get your answer, and while you think about it, if so, the question then becomes, why is the property owner being penalized for something that they had no part in if the law prevented the person from being there in the first place?
It may have changed, and I'll let Aaron speak on that. I think there was a change in the distance.
Change in the law.
In the law for regarding the distance at the time he purchased it.
Through the chair to Councilman Johnson. So the state law has 1,000 feet. So when he purchased the property, he was 1,000 feet from a daycare. City regulations changed in 2005 to increase that distance from 1,000 to 2,500. So he was grandfathered in prior to the city's requirements of 2,500 feet.
Did I not just hear, and I'm taking notes and forgive me if I got it wrong, I'm told this happened a year ago? The person got the property a year ago, or did I hear that incorrectly?
So the current owner purchased it a year ago.
The current owner of the
daycare. Of the daycare.
But this person who purchased the home had been there for 25 years. The sexual predator
has lived there, or at least has purchased the property and owned it since 2004.
Do we know if that person, that individual, and I don't want to call him the predator, I certainly understand that, and they paid their debt to society and we want to follow the law. If the individual, do we know if this individual is actually residing there or just owning the property? Do we know that specifically? I wasn't able to find it. I tried to research it myself, so that's why I'm asking the question from the dais.
The Florida Department of Law Enforcement has a sexual offenders and predator search. When you search this address, he does pop up as residing at that still
So not
that
just
same
owning
address.
it, but living in this place. If we are to grant this waiver, does that put the city, and this may be a legal question, does it put the city in jeopardy of, because we would then be, by waiving the rule, we would then be, I won't say violating, but going against the rule that we created. What legal jeopardy could the city be put in if if the appeal is upheld?
It would be the decision of the body to approve the appeal. So if you go ahead and grant that, what that means is you would not be in violation of a state law. It would be your own law or ordinance that you guys passed that changed it or enhanced the distance requirement.
But through the chair, from my novice understanding of procedural law, the issues then come about when you begin to violate the rules that you set on yourself. So my question then goes back, does this mean that if we are saying, yes, we made the law, but we're going to waive the law, which we do all the time, which we can, does this set us up, in your opinion, legally for a court action that could be unfair to us or end up with us having to some damages need to be?
Yeah, I wouldn't be able to give you that analysis without further research, and simply because it depends on who would have standing in order to bring that suit. So that would require additional information and facts that aren't before me to make that decision, or for you guys to decide before the body tonight.
Thank you. Thanks, Mr. Chair.
And I'll just add this too. I mean, and not that I've had a vast, experience in this, but I think because it has to do with competent and substantial evidence, the rule that we set with 2,500 feet or 1,000 feet is going to be almost irrelevant whether we go by that or don't go by that. The judge is just going to look at the competent substantial evidence and whether we had it or didn't have it. Similar to, if planning department, issues a recommendation of denial and we say, yeah, okay, we're still going to do it because the competent substantial evidence overrides that, then that's sort of what the, courts would look at. So that's just my kind of 2 cents, but excellent kind of line of questioning there. Ms. Pittman, you are recognized. Yes, ma'am.
Thank you so much for giving me the opportunity to speak on this, and I want to keep it on basically the variance. I think in this case that this daycare have shown that the provider has provided services. Recently, we had another daycare that closed in this community, and based on the information that was given to me, this daycare provides and have not had any issues in 20 years regarding legalities, whether it's this person who is a predator or anyone else. And my concern is providing services as a provider to the community. I've driven around in that area. I even lived in that area before. And I want to make sure that we already have enough disparities in this particular area. There are a lot of working parents in this area that needs this service. If this is not passed or if it's denied, there will be no services in that area for children are being served by this provider. So I would like to say, consider this so these the owners can continue to serve this need in the community. And I'd ask you, this is almost like the liquor store. If you think about that, the liquor store, we move from, one square footage to another, and there were variances over all communities, not just District 10, but there's been variances that has been approved. So, I feel strongly about this daycare having history in that community, and it is very well needed in the community. Thank you.
Okay, let's go to Councilmember Freeman for the first time, and then we'll come back to Councilmember Gaffney for the second time. Councilmember Freeman, you're recognized.
Thank you, Mr. Chair, and through the chair to Councilmember Pittman. Thank you so much for sharing that. I was really looking to kind of hear your thoughts. I will say that when I initially saw this, I definitely was troubled. Former educator, still coaching, always on the field, always around kids, always going to do whatever I can to protect them. Listening to the conversation, one of the questions that I wanted to ask, and I will make it more rhetorical, was just when we can always make laws stronger at the local level from the state. What did we base the criteria on when we came to the distance? And so that, without that understanding right now, and without really trying to seek it, I do know the need of it. I'm going to yet again, probably in my own way, side with, as a former representative of that area and understanding it, I'm probably going to go with the need of the kids and helping parents who are probably out working. But this is a tough one. And I love where Councilmember Johnson was going in the beginning in his line of questioning. It didn't stick the landing, but you got me halfway up in the air doing some backflips, and I don't know, it's not going to be a perfect 10 on the landing, but I really, there's more substance here. But I think I'm just going to keep it really simple. Appreciate you sharing, and I'm stuck on that variance as well, so thank you.
All right. Councilmember Freeman's going with non-baseball analogies now. We know what his daughters are doing in front of me. Anyways, just a collegial comment. But all right, we'll go to Councilmember Arias for the first time, then we will come to you, Councilmember Gaffney. Councilmember Arias, you're recognized.
Thank you, Chair. I too was also on the fence on this. The facts are this. If this is really one of the biggest issues that we're facing tonight. Nobody has came in opposition, number one. Number two, the council member for the district is fully supportive of this. She stated that this is a need in the community, in her community, our community in Jacksonville. And the facts are this: that daycare has been operating for over 25 years, as already stated. One, this individual has resided there for over 20 years. Two, so in the last 20 years, clearly nothing has happened. But also, the biggest thing is that we are abiding still by state law, which is 1,000 feet. By having this variance going to 1980, we're still double the state mandate, essentially. So I don't see the issue reducing it, by another 520 feet. I'm going to support this primarily because this is a much needed asset in the community, but also because it's already been established. If it was a brand new business, different story, I would not support this. But this business has been already there for over 20 years, and so has this individual. So I don't think we should take this away from the community, only because of some technicalities on some numbers that we created here locally. But once again, if this was a new business, that's where I would draw the line. All right, thank you. I'll be supporting this.
All right, Councilmember Gaffney, thank you for waiting. You're recognized.
Thank you, through the chair. Ms. Brock, if you don't mind, you could come up. Is she here? Yeah. Good afternoon. Good evening. How you doing?
Hello. Can you hear me?
Yeah, I can hear you. Good. Thank you, through the chair. And I'm assuming you're the daycare owner, correct?
Yes, sir.
So my biggest concern is the parents, and I'll allow you and the kids, obviously. And you the daycare owner. I just want to get your thoughts on this before we move forward. Like I said, my biggest thing is safety. I understand the variance, the feet. I just, as the owner, protecting the kids, you've been in the community, just want to get your opinion, your thoughts before I make this vote.
As far as safety?
Yeah, of the kids, yeah.
Yes, sir. I have been running my daycare center for 20 years, and safety is our top priority. I was telling my partner, since we were having such difficulty in this area, that I am willing, as far as safety, to I have a agency who can come by and do. I'm so sorry. I'm really nervous.
It's fine. Yeah, it's fine.
I'm nervous. Yeah. Security for us on site if necessary, but as far as security, I have alarm systems. We have codes where parents cannot get in unless they have a code to get in. I also do background checks on my parents, because you never know, as far as safety for the kids. As far as parents allowing anyone to pick up their kids is not allowed. If they're not on our list or in our database, the children are not allowed to leave without the parents' permission.
All right, thank you. So, if the daycare owner feels safe about this, I'm going to support the daycare owner, and I'm going to support the current council person that's over this district. So I don't see no other issues with it. We had some opposition from the daycare owner, some opposition from the council person. Then I might have some reservations, but I'm good for this.
Okay. Well, with that, we'll go ahead and close the public hearing and bring it back to committee. We have two amendments real quick. We have amendment number 1 and amendment number 2. So we're going to take these up separately. So we need a motion on amendment number 1.
Amendment number 1. Second.
All right. Motion and second on amendment number 1. It's really just a Scrivener's error. All in favor of the amendment signify by saying aye.
Aye.
Any opposed? The amendment carries. Now, Mr. Harvey, please go ahead and very clearly let us know what amendment number 2 needs to be in order to grant the appeal or deny the appeal.
Correct. So the current legislation is drafted in not a posture of approval already. So you guys need to move to have an amendment that would grant the appeal or deny the appeal. So whoever's going to make the motion should specifically state that they're granting the appeal for the variance 2522.
And if we grant the appeal, then that means the daycare can be there.
Correct. This would be the final act of for this appeal.
Okay, awesome. So with that, it sounds like from the body we've kind of got mostly consensus on granting the appeal, and so let's take the motion to grant the appeal, and then we'll take a vote on that. Okay, we have a motion and a second on the amendment to grant the appeal, which would allow the daycare to stay at the current location. So with that, all in favor signify by saying aye. Aye. Any opposed? The amendment carries. So now let's go ahead and roll both of those amendments up into one LUZ amendment or whatever you want to call it. And now we can move the bill as amended. Motion and second on the bill as amended. Councilmember Johnson, you're recognized.
Thank you, Mr. Chair. Glad we're able to get this moving forward. I wanted to say I was researching this because I found it quite interesting as to how a law that was made, it was like a going back and forth, and so that's why I really got into the nitty-gritty of this. I think this is important because, as a councilwoman said earlier, this is something this community needs, and having seen this community and been there a lot, childcare, as expensive as it is, this provider is providing an affordable solution. I've made some calls, wanted to find out that she's one of the most affordable child care places on the north side in Jacksonville, so I'm told. So thank you for the work that you're doing in supporting this community. I also understand that we're trying to work for public trust, but in this, I believe that we are not just following the spirit of the law, but the letter of the law as it comes to the state level, as we discussed here, and the intent of the zoning code. So I will be supporting this tonight. Thank you, Mr. Chair.
All right. Thank you so much for those comments. I think that is pretty much the sentiment that we've experienced here tonight. We hate to see where a business basically changes ownership and then all of a sudden they have to do a mad rush to keep everything the same in order to accommodate, one, individual that's in the area or multiple. It's kind of unfortunate the way the timeline laid out. So anyways, with that being said, we will open the ballot and record our votes. And if you're voting green, that means we will be granting the appeal for the daycare to stay.
6 yeas, 0 nays.
By your action, you've approved 2025-845.
Thank you, Mr. Chairman. If you want to go by and see the site, and you want to go the weekend, the Mighty Tigers are playing there this weekend, you can use Mr. Gay's suite in their gym. His suite's almost always empty. So.
Go look at Reball. New school.
I don't know Reball.
Ongoing joke, audience. Ongoing joke and jabs that we experienced from Mr. Harden. Ms. Pittman, you're recognized.
Colleagues, I just want to say thank you so much for supporting this, because I feel like the impact that this daycare has made has been tremendous and will continue to do. Thank you so much.
All right. Thank you for coming to speak to it. We do appreciate that. All right. Next, we will go to, actually, we're going to go to item number 3 next, but before we do that, just to get these kind of deferrals out of the way, item number 1, 2025-487 is deferred. Item number 2, 2025-488 is deferred. Item number 3, 2025-630, open the public hearing. No speaker cards. We'll continue this public hearing until 1/21/26. Item number 4, 2025-675. Council members, please declare any ex parte communication you have at this time. Let's see. 2025-675. Councilmember White, you're recognized.
Yes, sir, thank you. I want to declare ex parte. Talked to Mr. Phillips today. He came to my office, and I also talked to Josh Cockrell on the phone this afternoon, and both will be filed. Thank you.
Councilmember Johnson, you're recognized.
Thank you so much. I spoke with Mr. Phillips earlier today about 1 o'clock. I had some questions that were answered about this and how they were mitigating these issues. All will be filed with Legislative Services. Thank you.
Councilmember Freeman, you're recognized.
Thank you, Mr. Chair. I'll rise to declare ex parte as well. I spoke with Mr. Hayden Phillips in my office today. He shared the details of the project, and the necessary paperwork has been filed with Legislative Services. Thank you.
Councilmember Arias, you're recognized.
Thank you, Mr. Chair. I also rise to declare ex parte. I spoke to Mr. Phillips yesterday at 8:45 a.m. To discuss the details of the project, and I also spoke to Mr. Cockrell today regarding the project, and it's currently being filed. Thank you.
Councilmember Gaffney, you're recognized.
Thank you. Thank you, through the chair. I'm not sure if I need to file ex parte or not. Mr. Hayden Phillips, he sent the email to my office during the Christmas break. We didn't respond, but I file anyway, just to make sure it's on record, and I'll make sure it get filed. Thank you.
All right. And I have ex parte to declare. I met with Hayden Phillips in my office on January 5th at 11 a.m., and we discussed the bill and the community involvement, and this paperwork is being filed with Legislative Services. So with that, we will go ahead and open the public hearing and get a staff report.
Thank you. This is conventional rezoning ordinance 2025-0675, which is seeking to rezone approximately 11.25 acres from RR Acre to RLD 60 in order to permit the development of single-family subdivision. The property would be allowed to be developed with a maximum of 81 single-family dwellings with the existing land use designation of low-density residential, which would allow for a maximum of 7 units per acre. But the applicant did submit a JEA availability letter, which would requested services available for 47 single-family homes. The subject site is located along Cedar Bay Road, which is a local roadway and is approximately a quarter-mile east of Main Street North, which is classified as an FDOT principal arterial roadway. 47 single-family dwellings could produce up to 427 daily trips. Cedar Bay Road is a mixture of single-family developments along the north side, which are mixed zoned for RLD 60 and a couple of PUDs. Neighboring subdivision, Cedar Bay, is developed to the RLD 50 standards. Those are approved through a PUD back in 2003. And south of Cedar Bay Road is an industrial development complex. We find the requested rezoning meets all of the criteria as evaluated within the staff report and is consistent and compatible with the established pattern of development along Cedar Bay. So we forward a recommendation of approval. The application was heard by Planning Commission on December 4th, where there was one speaker in support. That this was a representative from the adjacent Cedar Bay neighborhood. And then there were several speakers from the Bay Harbor subdivision who opposed the rezoning. Concerns that were raised during the hearing included increased traffic, reduced lot sizes that were out of character for the surrounding area, and then also a desire to preserve the tree canopy along this roadway. The commission felt that the RLD 60 lot sizes would be consistent with the surrounding neighborhoods and the existing zoning along Cedar Bay Road, so they voted unanimously for approval.
All right. Thank you. And first, we will go to the applicant, Hayden Phillips.
Good evening, Hayden Phillips, 1301 River Place Boulevard. So this is about 11 and a half acres. It's on the north side of Cedar Bay Road. It is 0.2 miles east of the intersection of Main Street and Cedar Bay Road. It's currently in the low-density residential land use category, RR Acre zoning district, and suburban development area. What we're proposing is a simple conventional rezoning to RLD 60. As Aaron stated, our current plan is 47 lots. That comes out to about 4 units per acre, which is well below the 7 units per acre the underlying land use category would permit. And the lots will be 60 feet wide, maybe some larger down near the river, the Broward River. That said, the average lot size we have planned is almost 7,000 square feet. It's closer to the minimum in RLD 70 than RLD 60. But most importantly, if you look at the map, this is an infill site. It is an opportunity to provide more housing in an urbanizing area of the city. It is located 500 feet from the urban development area. It's 1,000 feet from Main Street, which is an FDOT principal arterial roadway, the highest and most intense classification of roadway other than an expressway that we have in our city, and it's well within the 295 loop. Most importantly, RLD 60 on this site will make the property consistent with the vast majority of Cedar Bay Road, which is zoned RLD 60, including the property directly across the street. One exception to that is the Cedar Bay neighborhood, which is located further east, further in on Cedar Bay Road, which has 156 homes that are 50s and 60s, so most of them even smaller. I attended the CPAC, who voted to approve this rezoning. We certainly coordinated with District Councilman Gay from the very beginning before filing anything. We held multiple community meetings. The feedback we received was sort of narrowed down to they wanted certainty. We promised a site plan. We created one before hosting another community meeting. We provided it to them. Also, active recreation there was a big emphasis on that. It's only 47 lots. We tried very hard to fit some active rec on our site, but we were unable to. What we did is work out an agreement with the Cedar Bay neighborhood where we committed to providing a very significant monetary donation for the active recreational uses in their neighborhood. And we are actually in discussions currently with the Bay Harbor neighborhood, which is to our west. We have offered the exact same agreement to them, waiting on a response. Happy to answer questions. If you will, my client, the developer, Ken Atlee, is here. If he could speak next. He submitted a speaker card. Thank you.
Yeah, he's already next in the queue. All right, Mr. Atlee, come on down, name and address, please. Thank you, sir.
Ken Atlee, 5851 Timuquana Road, Unit 301. I'm a developer. My company name is Atlee Development Group. I've been developing here in Northeast Florida since 1984, which probably explains the abundance of gray hair that I have. And we are negotiating with a very good builder, Chuck Hires, with Ashley Homes. He focuses on the move-up market and move-up products, so we expect very lovely homes to be built here. We would greatly appreciate your support, and if you have any questions, I would be glad to answer.
All right, thank you so much. Next, we have Catherine Del Rey, followed by Barbara Broward, and last, Josh Cockrell.
Good afternoon. My name is Catherine Del Rey. My address is on file. We have very valid concerns about the high-density developments being approved for the north side. It's all the clear cutting that is of major concern. The benefits of a healthy tree canopy are plentiful, but Northeast Florida is losing tree cover. According to a recent report commissioned by the Florida Forest Service, Jacksonville has lost 19,000 acres of trees since 2021. Trees are sponges for rainwater that no man-made product can match. Trees are not only important to control flooding, but are very important to protect us from high heat. A single tree can lower street level temperatures by 2 degrees. Heat is a public safety issue. Trees planted on the southwest exposure of our homes reduces our electric bills. Developers replace all the trees in clear cutting with young trees that will take 30 to 40 years before they can give us protection of the existing trees. For these reasons, I respectfully ask LUZ to vote no on Ordinance 2025-075.
Okay, thank you. Next we have Barbara Broward.
Yes, my name is Barbara Broward. I live at 717 Cedar Bay Road. I'm opposed to this type of development because Cedar Bay Road has consistently had large lot sizes. It's a small community with one way in and one way out. In 1968, a resolution was passed to support the protection of Cedar Bay Road as a residential road with no entrance into an industrial park and no industrial park entrance onto Cedar Bay Road. It was always to be a small waterfront community designed for single-family homes. The lot sizes are quite large. They've gone back to a development that began in the 1940s. And in the 1940s, Ida Broward started selling some property off, and it was in acre sizes. Some off the water were half-acre sizes. We've always been a very low-density community. In 2009, there were some ordinances passed, 5 of them, to uphold our original 1968 development of resolution keeping Cedar Bay Road a residential road and no entrance into the industrial park and always a dead-end road. To build up against a development like Bay Harbor is not actually inconsistent with the way that Cedar Bay Road has been developed. I would like to read into the record a letter from Mr. Berryman, who was a developer who developed Bay Harbor. This letter is dated July 22nd, 2003, in reflection of the development of the Bay Harbor subdivision. I would like to express my heartfelt gratitude to the Cedar Bay Road community, the involvement and support from the conceptual plan to the present success. As a developer, our original conceptual plan was slated for a 72 quarter-acre lot size. After listening intently to the community concerns and interest, as a developer, we felt strongly about revising the design to a 35-lot, half-acre lot design.
All right. Thank you, ma'am. Your time is up. I'm sorry. Our next speaker is Josh Cockrell.
Mr. Chairman, council members, Josh Cockrell, 462 Auburn Oaks Road East. I live in the Cedar Bay neighborhood right adjacent to it. I'm currently the vice president of the HOA and the past president of the HOA. We represent approximately 154 houses in our community. On behalf of the community, we fully support this project, so I am speaking on behalf of all of our homeowners. What's transpired over the years since I've lived in this neighborhood since 2017, I've noticed we have a lot of active duty military in the community. And when they get orders, they sell their houses quickly. That suppresses our comps that are available in the area. There's no other community area that provides any sort of comps that for compared to what we have otherwise when it comes to real estate. So Having a new community adjacent to ours is going to help our home values. We fully support it. And we fully support the work that the developer and his agent has done in working with us in our community, understanding our concerns with recreation and the contribution they're making towards our community in doing so. As the agent has stated already, and putting on my hat here, it's you look at the GIS map, you'll see on the land use zoning map, you have RLD 60 all the way down Cedar Bay Road, the entire community. Across the rivers, RLD 60. The substantial competent evidence is there to support this. The lots to the east, though they're all longer lots, can all be developed in the future into, smaller lots and broken up, and subdivided. So this is something that we do fully support. We hope that you'll support this as well, and we thank you very much.
Okay, we have no other speaker cards, so with that, we'll close the public hearing and bring it back to committee. All right, we have a motion and a second on the bill. Let me see if there's anybody in the queue. We have no one in the queue. Councilmember, okay, yeah, I was about to ask, if you want to speak. Go ahead, you're recognized.
Thank you, Mr. Chair. This community, this development is pretty, I guess, hits close to home, so to speak. We've had a couple of community meetings to discuss the concerns of the communities, and so some of the stuff that's being presented and talked about tonight, I guess it's a little concerning that some of the community originally in the meetings were against this, and now that money is being thrown at different communities to develop certain playgrounds or whatever, now they're supporting of it, and that's fine for that little segmented community, but I'm looking at the whole community as in a whole, and that's where there's a disconnect. And so the one thing I kept hearing in the town community meetings that we were having about this was that not that they were opposed to the development, they were wanting a compromise, a potential, some bigger lots, not saying no to 60s, but saying, let's get something in there more compatible. The property to the very west of this is half-acre lots that it's going to, and on the other side of it is property that's is probably 2 to 3 acres that's on the other side of it. So there's kind of doing selective looking in comparison that's really not, that's taking the adjoining property out of the equation with this. With this development going in and contributing to the other development that's further east on down the road, there's no sidewalks planned to go for. They're not putting any community playgrounds in this new development. There's nothing to connect it to where they're doing the passing the money out at. So there's somewhat of a disconnect, and so we would like to see bigger lot sizes that are compatible. This particular developer at the end of Cedar Bay Road, that yes, there may be 60-foot lots, but at the end of Cedar Bay Road, by right they can build RLD 100, and that's what this developer is doing, RLD 100. So it's kind of not staying with the pattern of what the community is asking for. And yes, I live on this road. I'm zoned for RLD 60, but this same developer developed the lots that I'm on, and it's an RLD 90, or it's a 90-foot wide lot. So there is that flexibility, and that's what the community was asking was, let's compromise. Let's look at being able to have the mixture. And so that's kind of where where I'm hearing the the heartbeat of the community, not just a couple small segmented developments in there. So I'll go ahead and let comments come out, or speak, and I'll potentially speak again. Thank you, sir.
All right. Well, we don't have any speakers in the queue. So I guess if there's any questions or comments after hearing the district council member, now's the time to speak up. There we go. There we go. All right, Councilmember Johnson, you're recognized.
Could I get the young lady that spoke in the pink? Please forgive me, I don't recall your name. Ms. Broward, could you come forth to the chair?
Ms. Broward, are you out there? Yeah, we have a question. Councilmember Johnson has a question for you.
Oh, Ms. Broward, could you come up for me, please, through the chair? Thank you. Thank you for sharing with us. I appreciate you. I just had a question about, I noticed that you said some things about lot sizes based on the 1968 ordinance that was passed, which is obviously goes without saying that's the year the city was created, was consolidated. The question though, have there been any, in that time period, more than 50 years, any movement to have a development opportunities? I mean, obviously the city has expanded since 1968, but has there been any movement to say we're open to development or any other lot sizes? Could you give me your thoughts just that you've discussed with your neighbors, please?
Yes. My point was that Cedar Bay Road has always been a small community with large lot sizes. I myself sit on 3 acres. I own 2 lots. We have always welcomed development, and Bay Harbor was developed in a way that was compatible with what was happening on Cedar Bay Road. They had half-acre. He was proposing quarter-acre lot sizes. After meeting with all of us, he decided that he would move up to half-acre lot sizes, and he was very pleased to be a part of a community that was moving forward in an upscale way. My point in saying about the road is that we have one way in and one way out, and we have to think about density. And since Cedar Bay Road has always been a very low-density area, we have to consider how we're getting in and out. It has been suggested that perhaps we could go on to the industrial park side. But in 1968, there was a resolution passed that has been held up in court twice to maintain Cedar Bay Road as a residential road only, dead end, no entrance into the industrial park, and no industrial park entrance onto Cedar Bay Road, keeping us a residential area and the industrial park a industrial park area. That's the way it was been. Now, in 2000,
we got our question answered. So for this time, we can't have any additional comment. So thank you. We appreciate your time. Okay, thank you, Councilmember Johnson. Now, Councilmember Arias, you're recognized.
Thank you, Mr. Chair. I was just looking up some property stats here. So any lots with 60 foot RLD 60s, you can do up to 3,000 square foot homes. That's a pretty significant size house right there as it is. So, Mr. Gay, we've been, especially in the last couple months, we've seen your community come up here constantly. And the only issue I'm having with it now is that they're constantly always wanting the same thing, and it's all over your community, which is not fair for other districts because you guys are all getting the larger lots. We're the ones having to deal with the density issue, not you guys. So we have to come up with a solution for your district, and you have to tell them, hey, we also have to put our fair share of lots and density in our district as well, too. It can't just all be on the south side. It can't just be in San Marco. So I want to support you, but if this was the first time, this is not the first, second, or third. You've been up here multiple times. It gets to a point where I'm listening to your community and I'm like, guys, Jacksonville's growing. There's going to be density happening in Jacksonville. You guys have a lot of area, a lot of square footage in your piece of town. On my side, in E-Town, there's a lot of development happening too. I can't tell the developers. I mean, I can't, but it's not going to be fair for me to tell them, hey, only 100, RLD 100, because I don't want any density. So the fact is, if people don't want density, go somewhere else. It's coming to Jacksonville, so we have to be able to conform to that. I'm okay with seeing what kind of solutions you guys want to talk about, but for any other future, rezonings, we have to come up with some density compromises. It can't just be larger lots only, because that's what I'm hearing, and I'm getting fed up with it. I want to see a little bit mixed use as well too, some density, some townhouses, some condos. Once again, I'm going to leave it up to discussion, but I'll support you with this one. But just moving forward, it's already kind of getting to an end with me on that part. Thank you.
All right. And just there's Mr. Gay's in the queue, and I'll just chime in on one thing on the density matter. Keep in mind, this is low density. It's literally the name of the zoning, residential low density, and this is a conventional rezoning. So even if we wanted to say, hey, build RLD 90 lots inside your RLD 60, similar to what's next door, they don't really necessarily have to do that, or they could still just revert back to the RLD 60s and do that if they wanted to. So it's kind of hard since it's not a PUD, it's just a conventional rezoning. So that's sort of where I don't know how we can kind of get to the compromise of like bigger lots, because you can't like do a hybrid zoning necessarily. But anyways, Mr. Gay, yeah, you're recognized. I would still want to hear kind of your thoughts after you've heard some of the committee. Oh, Councilmember Gaffney, do you want to? Yeah, okay, go ahead. You're recognized.
Councilman Gay, through the chair. My question is, yes, what will be a compromise? I assume and I thought the playgrounds, and maybe I heard it incorrect, that the playgrounds, the recreation space, the green area, I'm not sure how much money was invested, but I thought that was the compromise. What's your thoughts towards this? What is the compromise? I mean, do you feel like your community is getting a less short end of the stick for this development?
Yeah, well, for this one, what we heard repeatedly from the community was the Bay Harbor property development that is right to the west of this property in question was half-acre lots, and going to the RLD 60 from an RR to RLD 60 was a big jump, and the community was wanting something that was more compatible to the Bay Harbor community right there. So to answer your question.
Okay. We don't have any other speakers in the queue. So, all right. Yeah, Mr. Gay, go ahead. Yeah, if you want to give us some closing remarks here or any other additional feedback.
Yes. Thank you, Mr. Chair. I was just responding to him, but I still wanted to.
Okay, sure. Go ahead.
Just to represent my community out there, to say we don't have townhomes and apartments. Yes, we do have. We have that. Yeah, but that don't need to be the heartbeat or the drive to, that's all we're going to get, and that's all that we should plan for the future. No, people have their adjoining property rights, and to say they don't have a say in it and they basically to move out, that's not a good thing to say. And so I will. We can say we get tired of them coming in. Well, the community gets tired of seeing we call it low density, but we're not seeing the adjoining developments to the adjoining property compatible, staying with that compatibility. And that's what we've got to go back to look at the 2045 comp plan and make sure that we are standing in line with that of what's in black and white, not what interpretation is. And that's what we hear so much about is our interpretation. And so that's where, I'll always listen to the community, listen to the developers. I met with them all and tried to find that common ground. So that's where we are on this, and I appreciate y'all's consideration on it. Thank you.
All right, Councilmember Freeman, you're recognized.
Thank you, Mr. Chair. I actually thought my colleague to the right was in the queue, so I was going to follow behind him. But one, I want to thank Councilmember Gay. He always fights the good fight and puts forward a good argument. I live up in this area as well, and so I was going to add a little more context with the number of concerns that I have coming with the amount of apartments that are multifamily that are coming. But I also understand that there is a need in our city. But where I'm going to hang my hat is going to be with the fact that there were some constituents that came up. There were citizens that came up, and I did have a meeting with Mr. Phillips, and maybe Councilmember Gay can. I think he's already spoken to this, so it may not change where he's at. But that one group decided to get $45,000 to do something. I'm not quite sure what it is they're going to do with it, and they represent a certain number of homes in that immediate area. And that the other group on the other side from the diagram that I saw, they're negotiating now some type of a deal, maybe with a boat dock or something that they're interested in, which these are citizens, these are members of the community as well. And we always have them on both sides, but I'm like, if I have two groups that are working together and they live in close proximity, what does that number compare to the groups as a whole? So for me, I think I may land with those that have come and spoken up, but I do agree with you in the conversations that we move forward with something. We've said this before in the last one of some type of an idea of when we're bringing product to the market, and at least in this area of town, it's one of the few areas where we have trees still remaining. How are we going to approach it? And so I'm curious to have that conversation. I'm very much in favor of development and smart growth, but we're running out of spaces to put it. And it's west side, which is Councilmember White, and it's north side right now, which is Councilmember Gay. That's really all we have left outside of him. We got you earlier in 2007. So they got the E-Town part. Yeah, thank you.
All right, Councilmember Johnson, you're recognized.
Thank you for that brilliant insight through the chair to former Council President Freeman. I certainly see where you're going there, and also to Councilman Arias. It seems as though you're absolutely right. Like, I'm hearing it over and over and over again about the north side saying, "Hey, we don't want this density there." But then where does it go? Where does it go? I'm looking at both sides, and I'm understanding, based on the research I've done and the conversations I've had, that the community, one of the reasons why the community was concerned about their recreation equipment, because they were thinking the people that are coming in would use their equipment. So those funds would be to mitigate that. And they were specifically, correct me if I'm wrong, specifically for recreation equipment in that community, to maintain them and to allow them to be accessible to the others. The other side of that neighborhood where the boat dock access can be, they would have that same aspect and they would get the same amount of funds, but to have that recreational part there, which helps beautify the entire community. But at the end of the day, I think where I'm, to use a phrase from Councilman Freeman, landing the plane, is that people need a place to live. And I am just, while I'm certainly understanding of the community and the integrity of the community that's been there for decades, I also understand that progress must take place. And it doesn't seem like this is a non-sustainable way. While I did have some questions about road density, I looked it up, and usage on the roads, while I don't know the specifics of it, it looks as though it would still be well under 40% of usage if this development came about in this community. I still have yet to see a reason why it would be a no, because, again, the city is expanding. And while it was perfect for this back in the 1960s, in 2026, we want to do something different. And so I'm reminded of a great man in this community who's passed on. His name was Bernard Gregory. And he said, if you've done what you've always did, you'll get what you always got. I'm looking to get something different, and progress is what it's about. And so that's why this seems, though, unless I hear something different, something that's supportive that would help enrich Jacksonville as a whole. Thank you.
All right. We have no other speakers in the queue. So with that, I mean, you know, for me, I don't think I need to weigh in much more, but it seems kind of like, again, if there was a way to amend this, which, and Mr. Harvey, correct me if I'm wrong, conventional rezoning, you can't condition it. You can't say, hey, you got to have 3 lot sizes that are RLD 90. You can't do that. And then, you know, vice versa. If you make them all RLD 90, and that's not a compromise, that's just a overreach. So it's hard when it's just a conventional rezoning. But you know, I respect the history of this area, and you know, but there's neighbors that came down here and spoke, and then there's, you know, I don't want to discount. You know, I know Mr. Cockrell came down, and he was one person, but he represents 150 homes. I mean, that's a lot of people, and they had contention. You know, they had heartburn over the playground area getting overused, and that's a legitimate concern. So for me, you know, it's definitely a kind of a tough one, but I see, you know, I think, is it 47 RLD? Yeah. So 47 single family homes. I mean, that's a great, you know, development. That's not a bad thing for the area. So I'll be supportive of it. If there was a way to condition it or a way to, you know, amend it, I certainly would support that, but we're legally not able to do that. And I think we've even asked at one point in time the applicant to do that, and OGC said, no, you can't do that. So that's where I'm going to land on it. We have no other speakers in the queue, so we can open the ballot and record our votes.
Yeas, 0 nays.
By your action, you have approved 2025-675. All right. Mr. Gayer, do you have any other ones tonight? No? That one's it? All right. Seemed like there was a big sigh of relief there. All right. Number 5, 2025-724 is deferred. Item number 6, 2025-757. Council members, please declare any ex parte communication you have at this time. Number 6, 757. Councilmember Johnson, you're recognized.
Thank you, Mr. Chair. I rise to declare ex parte. I had a conversation, since this is in my district, with Mr. Phillips earlier today. It's currently being filed with Legislative Services. He discussed with me, I had some questions about the impact of the project, as well as some of the consumption language that's there. Again, filed with Legislative Services. Thank you.
Councilmember Arias, you're recognized.
Thank you, Chair. I also had a conversation. I'm also declaring ex parte. I had a conversation with the applicant yesterday, the same conversation from the last bill, and so it's currently being filed with Legislative Services. Thank you.
Councilmember Freeman, you're recognized.
Thank you, Mr. Chair. I, too, have ex parte. I met with Mr. Phillips in my office, and he shared the particulars of this issue, and this will be filed with the Legislative Services. Thank you.
All right. Councilmember White, you're recognized.
I'll also declare ex parte, same conversation when we was talking about the other one when I met with Mr. Phillips today, and that will be filed.
All right, and I also have ex parte to declare. I met with Hayden Phillips in my office on January 5th at 11 a.m. We discussed the site plan and community involvement. This paperwork will be filed with Legislative Services. All right, with that, we'll go ahead and open the public hearing and get a staff report.
Thank you. This is PUD rezoning ordinance 2025-0757, seeking to rezone approximately 5.5 acres from a parcel that is split zone between CCG1 and CCG2 to a PUD to allow for the development of a personal property storage facility. This is going to be on parcel B. If you look at the site plan, this is the parcel furthest south on it, on the lot. And then parcel A will be developed or allow for development of commercial and medical uses. With a revised site plan that's dated November 18th, parcel B does currently show the development of a freestanding emergency department, which is going to be approximately 24,000 square feet in size. The subject site is located at the southwest corner of 103rd Street, which is classified as a minor arterial roadway, and Harlow Boulevard, a collector roadway. Staff has reviewed the request and finds that the proposed rezoning is consistent with the comp plan with the existing land use category of CGC. So because of these reasons and those in the staff report, we are forwarding a recommendation of approval with a revised written description. You have a copy of that revised written description in front of you that's dated December 18th, 2025. And then a revised site plan also listed in your agenda. In the staff report, there were some transportation-related concerns, which generated the need for one condition. Since the issuance of the staff report, the applicant has addressed those concerns with the revised written description. So therefore, the department is only forwarding a recommendation of approval with no conditions with the revised written description and site plan. This application was heard by Planning Commission on December 4th. There were no speakers in opposition and little discussion from the commissioners, and they voted unanimously for approval with no conditions as well.
All right, thank you. We have one speaker card, Hayden Phillips.
Thank you. Hayden Phillips, 1301 River Place Boulevard. This is 5.5 acres on the south side of 103rd Street, about a quarter mile east of 295. It's currently CGC land use, suburban development area, and CCG 1 and 2 zoning, split zoned, which already allows the uses that we are seeking, but we are seeking a PUD for the medical clinic in the front, storage in the back. So low intensity, low traffic uses, be a great asset to this part of the city. We have coordinated with the district councilman. And so this is a pretty simple one. I'm happy to answer any questions if you have them. The PUD is just basically to solidify the site plan and tie up a few loose ends. The revised written description is correct, is dated December 18th. I did also want to ask Mr. Harvey if we need to address the amendment to the ordinance language that we addressed in the agenda meeting.
Yep, after the public hearing is closed and we get to the committee. So are you done with your comments?
I'm done. Thank you.
Okay. Sorry. With that, we'll close the public hearing and bring it back to committee. Well, we have some amendments. All right. So we'll move amendment number 1. Mr. Harvey, can you explain amendment number 1? Is there anything to be worth explaining?
Nope.
Okay. All in favor of the amendment number 1, signify by saying aye. Aye. Any opposed? The amendment carries.
Amendment number 2.
All right. Motion and a second on amendment number 2. All in favor, signify by saying aye. Aye. Any opposed? The amendment carries. And is there a third amendment?
There is a third amendment, and it's to amend the uses in the title in Section 1 to include and personal property storage and medical uses. It's been vetted by the planning department and is already included in the PUD. Just the applicant wants it in the body of the legislation.
Got it. Okay. Councilmember Johnson, are you on that or?
Well, there was a part, not that specifically, so I'll wait because I have a question.
Okay, let's take care of this procedural thing and then we'll come back to you.
Thank you.
Can someone make the motion for that amendment number 3? Okay, motion and second on amendment number 3. All in favor signify by saying aye. Aye. Any opposed? The amendment carries. All right, so let's roll all 3 of those up. LEZ amendment, and then let's move the bill as amended. All right, we have a motion and second on the bill as amended. Councilmember Johnson, you're recognized.
Thank you so much, Mr. Chair. Mr. Phillips, just want to make sure, I noticed here, and I discussed it because I had questions about it, had not made any decision, but I wanted to make sure, based on the current zoning, though, the consumption, can you explain to me your understanding of consumption and what is allowed currently versus what will be allowed with this new zoning? New PUD, excuse me.
Sure. Yes. Thank you. So the current zoning is CCG 2 up front and CCG 1 in the back. And Aaron can correct me if I get any of these slightly wrong. But on the CCG 2 portion, especially, which is the majority of it, alcohol uses of all kind are permitted. Restaurant for on premises, retail sale for off premises, and so those uses we held them over, and they are also permitted uses in our PUD. In addition to that, if you are within 1,500 feet of a church or a school, you have to get a waiver, which is extremely routine. There are a number of establishments that are actually listed out in the written description along the segment of 103rd that sell alcohol within the same distance, and they have clearly gotten those waivers or they're in violation. So we have sought that waiver in this PUD. A prior iteration of this did not include the Baptist Medical Facility up front, and it included general commercial uses, such as a restaurant that might serve beer. So that was a sort of a holdover, but, in the event things don't work out with Baptist, we would like to have some flexibility. I think I answered your question. Of course, the site plan holds as a bearing on that as well, and the current site plan clearly shows a medical facility and a storage facility, neither of which will be selling alcohol.
Let's hope the hospital won't be selling alcohol. Thank you for that description. Just want to make sure that we're good with that as well. And the reason I want that on the record, because it's something that's already allowable, and it's not something, they're just moving it over into the PUD. Thanks for describing that, and thank you for your clarification.
Thank you.
All right, no other speakers in the queue. Open the ballot, record your vote.
6 yeas, 0 nays.
Oh, by your action, you've approved 2025-757 as amended. Item number 7, 2025-823. Let's open the public hearing and get a staff report.
Thank you. Ordinance 2025-823 is for a small-scale land use amendment to change approximately 2.49 acres from agriculture, AGR, to community general commercial, CGC, for 1.74 acres, and then from AGR to neighborhood commercial, NC, for 0.75 of an acre. This is in the rural area, and the purpose of this is to allow for commercial development to serve the area surrounding the interchange of I-10 and US 301. A companion PUD rezoning application has also been submitted for this site. The subject site is composed of 4 parcels, extending from Brandy Branch Road on the south to New Brandy Branch Road on the north. The southernmost 0.75 of an acre parcel located along Brandy Branch Road is proposed for the neighborhood commercial land use, while the remaining 3 parcels with frontage along New Brandy Branch Road are proposed for the CGC land use. The site is located approximately a quarter of a mile south of the town of Baldwin, west of US 301, and just north of the I-10 Expressway. This is a significant interchange with considerable truck traffic. There's a large truck and travel stop. I think it's the Love's Truck and Travel Stop. It's approximately 17 acres, and it is located immediately to the south of the subject site across from Brandy Branch Road. This amendment would promote commercial development at a node near the intersection of an FDOT principal arterial roadway and an FDOT interstate. The proposed PUD rezoning provides for some additional buffers and site design criteria to help to integrate those commercial uses. For these reasons and those in the staff report, the Planning Department recommends approval. The Planning Commission recommended approval of this item at their meeting on December 4th with a vote of 8-0 and minimal discussion. Thank you.
All right, thank you so much. We have one speaker card, Mr. Mike Sidner.
Michael Sittner, 1 Independent Drive, Suite 1200, on behalf of the applicant. This is a property assemblage north of I-10 along 301 and the 301 bypass. It's a commercial corridor. We're just north of a truck stop and just north of I-10. Again, heavily commercialized truck traffic. We've also been coordinating with the city of Baldwin for utility access. We have tentative approval with the mayor, and we're set to proceed to a hearing later this month for formal utility approval. Since the city of Jacksonville utility doesn't really go up that far, so what we do is we actually proceed with the city of Baldwin. They vote whether to extend utilities or not. And so our engineer's been working with their city and with the town engineer, and everything's been going well on that. With that, I'm happy to stand by for questions. Thank you so much.
Okay, we have no other speaker cards, so we'll close the public hearing and bring it back to committee. All right, we have a motion and a second on the bill. No discussion. Open the ballot. Record your votes.
Five yeas, 0 nays.
By your action, you've approved 2025-823. Item number 8, 2025-824. Council members, please declare any ex parte communication you have at this time. Scene 1, Councilmember White, you're recognized.
Yes, sir. Thank you, Chair. Just want to ex parte. I met with Mr. sitting here this afternoon in the office, and he talked about these projects. And on another note, and that will be filed on another note, this is his last meeting. He's moving to Sarasota, so we will miss you, and thank you for, you've always been honest with you, and that's appreciated. With us, thank you.
All right. Last bill, huh? That we're going to hear from you on. Oh, man. Well, let's drag it out. So, just kidding. All right, let's go ahead and open the public hearing and get a staff report.
Thank you. This is the companion PUD rezoning ordinance 2025-824, seeking to rezone approximately 3.69 acres from CCG1 and AGR to a PUD to permit a variety of commercial uses near the I-10 and the US 301 bypass. Staff has reviewed the request and finds that the proposed rezoning is consistent with the comp plan, with the land use category of CGC and neighborhood commercial, with the neighborhood commercial being the closest to the existing residential, which will allow for a transition of uses. The PUD will also offer protections to the neighboring residences by using increased setbacks and buffering, and also limiting height of proposed structures. And all access will be strictly from Brandy Branch Road. No commercial access will be provided to the new Brandy Branch Road, which is along the northern property boundary. The proposed rezoning is consistent and compatible with surrounding development patterns and is appropriate for its close proximity to the FDOT principal arterial roadway and the interstate. So because of these reasons and those in the staff report, we forward a recommendation of approval. Application was heard by Planning Commission on December 4th. There were no speakers in opposition and little discussion, and they voted unanimously for approval.
All right. Thank you so much. We have one speaker card. Mr. Mike Sittner.
Michael
Grand
Sittner,
finale.
One Independent Drive, Suite 1200 on behalf of the applicant. I don't have much to say on the application other than stand behind the competent evidence from staff. I did want to say thank you all. It's been an honor to work with you guys, and truthfully, Jacksonville is well represented with you guys, and just wish you all the best. And staff, Aaron, Susan, Helena, it's been wonderful since they've taken over. I will say applications have processed faster, and they are advocating on behalf of the city really, really well. And you might not hear and see all of it, but behind closed doors, they absolutely are. And thank you, guys.
And thank you. Thank you for saying that. We appreciate it. Councilmember Freeman, you're recognized.
Thank you, Mr. Chair, and through the chair to Mr. Sittner. Can you repeat that part about us being the best? No, seriously. One, wanted to thank you for your service. Two, ask you if you're getting any sleep. I believe congratulations are in order. I think you might have a little one at the house as well. So congratulations on that. And we hate to see you leave, but it's just until we meet again. All right.
Thank you.
All right. Councilmember Johnson, you're recognized.
Mike, I'll add to it through the chair. I hope that where you're going, that they will also have the Salem Amendment ready for you when you get there. But thanks. It's been an honor working with you. We didn't always agree, but the beauty is we were able to find ways and find paths forward. And I thank you for challenging me intellectually so that we can do the best for our city. Thank you for those kind words. And as Councilman Freeman said, we'll see you soon.
Yeah. All right. Councilmember Arias, you're recognized.
Thank you, Mr. Chair. I just want to just thank Mr. Sittner for obviously all the work that you've done in the community, working with us. But on a personal note, we never got to run any races together. I know why. You're worried about me beating you. But you did go over 1,000 miles for the year, just like me. I don't know if you beat me or not, but nevertheless, you're a great guy. So you will be missed, and wherever you're going, I know they're going to be well represented. So thank you for everything you've done.
Thank you, Chairman. Thank you. Thank you, Councilman Arias. If I can say, I will be in town for the rest of the month. So there is an open invitation if you do want to run and get burned. The invitation's open. So.
Well, I'm sure it'll be on video because Councilmember Arias is always running with the video stick.
There might be some technical difficulties after the race.
Yeah, I'm sure. Councilmember Gaffney, you're recognized.
Yeah, thank you, through the chair. I just want to echo the sentiments of my colleagues. Mike, it's been a pleasure working with you. I mean, you've been truly outstanding in terms of meeting the community halfway. It's rare nowadays that you find lobbyists, attorneys that want to meet the community halfway and they care about the community even though you don't stay there. So I appreciate that. I appreciate everything you have done for like the last year and a half that we have worked together. So I wish you best luck. We'll always be here rooting for you, and whatever we can do to help you out, let us know. All right, thank you.
Thank you.
All right. I'll go ahead and weigh in, jump on this bandwagon. Mike, you're a good man. Now, just real quick, though, where do you live? Do you live in District 5?
Not anymore.
Okay, good. All right. Just want to make sure I'm not losing, a good constituent here. I'd make you find a replacement. But No, man, just the way that you handle yourself, inside here and just in community meetings is always extremely professional. So whatever you're going to be going and doing after this, like, absolutely commend you on that. I know you're going to be super successful, and we'll all, still be here in Jacksonville if you decide to come back. So with that, we appreciate the kind words that you've said, and, it's mutual. So
Thank you, Chairman.
all right. With that, and all that is in the public hearing. So if you ever want to go back, if you're feeling down about yourself, you can go and get the minutes and reread that. Yeah. All right. So let's close the public hearing and bring it back to committee.
All right, let's move the bill. You want to defer it?
Oh, it's so tempting. Yeah. Yeah. He's like, I just hand it off. Yeah. All right. We have a motion and a second on the bill. Open the ballot, record your vote.
Zero nays.
By your action, you've approved 2024-824. All right. Item number 9, 2025-825. Let's open the public hearing and get a staff report.
Thank you. Ordinance 2025-825 is for a small-scale land use amendment of 2.45 acres from residential, professional, institutional, RPI, to business park, BP, in the suburban area. This application has also been submitted with a companion PUD application. The subject site is located on the west side of St. John's Bluff Road between Beach Boulevard and Alden Road. St. John's Bluff Road is a minor arterial roadway. Beach Boulevard is an FDOT principal arterial roadway, and Alden is a local road. The proposed amendment to BP would be complementary to the existing BP east of the site, maintaining a compatible land use pattern along the St. John's Bluff Road corridor. The subject site is approximately a third of a mile north of Beach Boulevard, which has a variety of commercial uses, as well as half a mile from the I-295 expressway. This degree of transportation access, along with the full urban services that the subject site has, meets the locational criteria for the BP category. So for these reasons and those in the staff report, the Planning Department recommends approval. Planning Commission heard this item on December 4th, and they voted to recommend approval with a vote of 8-0 and minimal discussion. Thank you.
Okay, with that, we'll close the public hearing and bring it back to committee. Actually, we shouldn't have closed the public hearing. We're going to reopen the public hearing. We need to get these cars a little faster over there. It's not my fault. It's his first day back. Okay. All right, we do have one speaker, Miss Megan Perkins.
Megan Perkins, 8051. I'm just here for questions.
Okay. All right. Did the Planning Commission take up the Salem Amendment?
I'm sorry, what?
Did the Planning Commission take up the Salem Amendment?
I don't know what to say. Are you messing with me?
Yeah. All right, we had to. I texted your dad. I said, does she know about the Salem Amendment? He said, no. What's the Salem Amendment?
So rude.
All right. It's because we tipped you off a little earlier when we said that to Sittner.
That's right.
All right, we got you a little bit. We got you. Okay. There is no Salem Amendment. Good job. You passed. We got you a little nervous for a second. Mission accomplished. So with that, we'll close the public hearing and bring it back to committee.
Second.
Motion and second on the bill. No speakers in the queue. Open the ballot. Record your vote.
0 nays.
By your action, you've approved 2025-825. Item number 10, 2025-826. Council members, please declare any ex parte communication you have at this time. Councilmember Arias, you're recognized.
Thank you, Mr. Chair. I am rising to declare ex parte. I spoke to the applicant on January 5th regarding this rezoning, and it's all currently being filed. Thank you.
Councilmember Freeman, Councilmember Freeman, you're recognized.
Thank you, Mr. Chair. I would rise to declare ex parte. I want to thank the applicant for texting me the information on this, and it has been filed with legislative services.
Councilmember Gaffney, you're recognized.
Thank you, through the chair. I want to rise to declare ex parte. The applicant texted me, I want to say this morning, but I'll make sure he asked me did I have any questions, but I'll make sure everything get filed with legislative services.
Councilmember Johnson, you're recognized.
Thank you, Mr. Chair. I rise also to declare ex parte. I spoke with the applicant via text message earlier today. I had some questions about this, and all's being filed with legislative services. Thank you.
Councilmember White, you're recognized.
Yes, sir. My ex parte spoke to Mr. Hart a couple of days ago, has been filed. Thank you.
All right. We have no further ex parte. With that, we will open the public hearing and get a staff report.
Thank you. This is the companion PUD rezoning ordinance 2025-826, which is seeking to rezone the same 2.45 acres from commercial residential office to a PUD to allow for flex warehousing and office uses typically allowed within the IBP zoning district. The PUD will allow for the IBP zoning district type uses, but will cluster development away from the existing wetlands that are along the western portion of the property, and also allows for that flex warehousing type product. The subject site is located along the west side of St. John's Bluff Road and is approximately a quarter mile north of Beach Boulevard. The eastern side of this roadway includes numerous warehousing and office type uses. Staff has reviewed the request and finds that the proposed rezoning is consistent with the comp plan with the land use category of business park, and we find it furthers the goals and objectives of the comp plan and meets the internal and external criteria. The proposed rezoning will be consistent and compatible with the existing development pattern along St. John's Bluff, which again includes numerous warehousing and office types uses. So because of these reasons and those in the staff report, we forward a recommendation of approval. Application was heard by Planning Commission on December 4th. There were no speakers in opposition and little discussion, and they voted unanimously for approval.
All right. Thank you so much. We have one speaker card. Megan Perkins.
Megan Perkins, 8051. Again, here for questions.
Questions only. Got it. No speakers in the queue. We'll go ahead and close the public hearing, bring it back to committee.
All right, let's move the amendment.
There we go. All right, we have a motion and a second on the amendment. All in favor of the amendment signify by saying aye. Aye. Any opposed? The amendment carries. Motion and a second on the bill as amended. No one in the queue. Open the ballot. Record your vote.
Zero nays.
By your action, you've approved 2025-826.
Thank you very much.
All right. Item number 11, 2025-827. Council members, please declare any ex parte communication you have at this time. Seeing none, let's open the public hearing and get a staff report.
Thank you. This is PUD rezoning ordinance 2025-827, seeking to rezone approximately 1.38 acres from CCG1 to a PUD to allow for a flex warehousing and mixed-use development. The subject property is located along Brookview Circle, which is just north of Atlantic Boulevard and west of I-295. The submitted site plan shows that the property will be developed with two flex warehouse buildings. One is proposed to be approximately 9,500 square feet, and the other is approximately 4,600 square feet. The proposed development is in an area with a variety of uses, which include commercial uses that are along Atlantic Boulevard, and to the west of the subject site is a PUD that allows for commercial type uses. And then as you transition north, you transition to residential uses. Staff has reviewed the request and finds that the proposed rezoning is consistent with the comp plan with the existing land use category of CGC. We find it furthers the goals and objectives of the comp plan and again meets that internal and external criteria. We find it's consistent and compatible with the development pattern existing. So because of these reasons and those in the staff report, we forward a recommendation of approval. Was heard by Planning Commission on December 4th. There were no speakers in opposition, little discussion, and they voted unanimously for approval.
All right. With that, we have one speaker card, the applicant, Kelly Delmonico.
Hi, good evening. My name is Kelly Delmonico, 355 Spoonbill Lane. We appreciate the opportunity tonight to come forth and request a PUD zoning, which is a very good way in this case to take some uses that are already allowed in the CCG1 zoning, plus several low-intensity compatible uses from both CCG2 and IBP. So we're thinking uses for flex warehouse. So AC, electrical, plumbing contractors, dental labs, cabinet shops, assembly and storage, all indoor uses, nothing outdoor. We provided a site plan and have offered examples on page 3 of Exhibit D, which is the written description, showing visually what we believe the flex warehouse would look like. So flex warehouse, it has a storefront door to an office, it has a roll-up door to a large flex space area, as well as a restroom. So this PUD is compatible with the comprehensive plan and offers protections to the neighbors. And with that, I'm happy to answer any questions.
All right. Let's See, we have no one in the queue. I'll just ask real quickly before we come back. Did you happen to reach out to the district council member?
No, sir.
No? Okay. Well, Mr. Amaro's not here, but I wish he was. Maybe he's listening. He said that he was going to be watching, but I'm sure if it was somewhat contentious or anything, he would absolutely be down here. So we'll go ahead and close the public hearing and bring it back to committee.
Let's move the bill.
All right, motion and a second on the bill. We have no speakers in the queue. Let's go ahead and open the ballot. Record your vote.
6 yeas, 0 nays.
Thank you.
By your action, you've approved 2025-827. Item number 12, 2025-828, open the public hearing. No speaker cards. Let's continue this public hearing till 1/21/26. Item number 13, 2025-829, open the public hearing. No speaker cards. We'll continue this public hearing till 2/3/26. Item number 14, 2025-830. Council members, please declare any ex parte communication you have at this time. Seeing none, let's open the public hearing and get a staff report.
Thank you. This is conventional rezoning ordinance 2025-830, seeking to rezone the property from CCG 1 and its split zone CO to bring the entire property under one zoning district of CCG 2. The property is requesting the rezoning in order to operate outside storage of trucks, which will require a zoning exception, which is the companion application that you'll hear next. That's 2025-831. The subject property is located on the north side of 103rd Street, which is classified as a minor arterial roadway. 103rd Street is a heavily commercialized roadway where surrounding properties are primarily zoned CCG2 or PUDs that would allow for automobile-based commercial uses. These types of uses along this roadway and surrounding properties include service garages, outside storage, car rentals, and warehousing. We find the requested rezoning meets all of the criteria as evaluated within the staff report and is consistent and compatible with the established pattern of development along this portion of 103rd. So because of these reasons, we forward a recommendation of approval. Application was heard by Planning Commission on December 4th. There were no speakers in opposition, little discussion, and they voted unanimously for approval.
Okay, thank you so much. With that, we will go ahead. Is there any public cards? No? Okay, we have. Is the applicant here? Okay, just want to make sure that you're here. You don't need to fill out a card. We just always like to make sure that the applicant's here. So with that, we'll close the public hearing and bring it back to committee. All right, motion and a second on the bill. No one in the queue. Let's open the ballot. Record your vote.
6 yeas, 0 nays.
By your action, you've approved 2025-830. Item number 15, 2025-831. Council members, please declare any ex parte communication you have at this time. Seeing none, we will go ahead and open the public hearing and get a staff report.
Thank you. This is the companion zoning exception, ordinance 2025-831, seeking to allow for the outside storage of trucks, but not trailers within the zoning district of CCG 2. As mentioned, this property is located along 103rd, with this portion being heavily commercialized with many automobile-based commercial uses, including service garages, outside storage, car rentals, and warehousing. We find the request to be consistent with the existing land use category of CGC and is compatible with the existing developments along 103rd, as previously mentioned. So because of these reasons and those in the staff report, we forward a recommendation of approval. It was heard by Planning Commission on December 4th. There were no speakers in opposition, little discussion, and they also voted unanimously for approval of this ordinance.
Okay. We have no speaker cards, so let's close the public hearing, bring it back to committee. All right, we have a motion and a second on the amendment. All in favor of the amendment signify by saying aye. Aye. Any opposed? The amendment carries. All right, motion and a second on the bill as amended. No one in the queue. Open the ballot, record your vote.
6 yeas, 0 nays.
By your action, you've approved 2025-831. Item number 16, we've already taken up. Item 17, 2025-859 is deferred. 860 is deferred. 861 is deferred. 862 is deferred. 863 will open the public hearing. No speaker cards will continue this public hearing until 1/21/26. Items number 2025, 885, 886, 887, 888, 889 are all on second reading, and that concludes our meeting tonight. This meeting's adjourned.